About 20 to 25 minutes.
Thank you. So I will be presenting the research conducted along with Professor Ivana Kunda. So what we have done is that we have tried to take into consideration, of course, the IMO classification of autonomous vessels. And we based this research on category 2 and category 3. And obviously, this is a very simplified depiction, so we can complicate this much more. As we have seen from Professor Vrbljanac presentation, we can include insurers, we can include classification societies, and so on. So from yesterday and this morning, my take is that mass raise complicated issues regarding liability, especially by introducing new liability players into the equation. And we have tried to highlight them in a different color. And determining who will be liable is complicated itself. And from the perspective of private international law, the issue is a bit more complicated, because first we have to establish what is the legal relationship between all these stakeholders. So we need to characterize a particular legal relationship between two stakeholders. So let's say that we are talking about a case of mass colliding with another vessel, and a damage occurs on cargo. Also, a vessel is damaged due to collision. We have also taken into account the actual mass, Yara Birkeland, which was, I hope I have pronounced this correctly, which was mentioned in the previous session, in order to establish what is the business model of companies which are connected to the vessel. So Yara Birkeland is owned by Yara International, which is the ship owner, according to information I was able to find online. And it represents a collaborative project between various companies, more precisely Kongsberg, which is responsible for developing and providing AI solutions, so technical solutions. And the ship is operated from the Masterly's Monitoring and Operations Center. And then Masterly is a joint venture of Wilhelmsen and Kongsberg. So we have connected companies here. And now our analysis is inspired by Yara Birkeland and these companies. So this is not a formula that will be universal. So we have to see how the business model connected to mass will develop. And the first relationship that we have taken into consideration is the relationship between the ship owner of mass and manufacturer of AI software. So from the Yara Birkeland's example, we have concluded that this relationship is to be characterized as a contract. Now, again, this can be done differently, and it is not a formula that will be valid also for other vessels. There can be characterization of this relationship as a non-contractual liability if the ship owner is further down the line. But in this example, let's say this is a contract. And from the perspective of the European private international law, and this is the perspective we took, regulations which apply, and I'm sure all of you have heard about the Brussels 1 bis regulation. This is the EU regulation which unifies rules on international jurisdiction for civil and commercial matters. And there are multiple provisions from the Brussels 1 bis regulation which may be applied for establishing which court is competent in case there is a dispute. Of course, assuming there is an international element. With IARA, I don't think there is because it operates between courts in Norway. And these provisions of the Brussels 1 bis regulation which may apply are first of all prorogation of jurisdiction, so parties are free to choose the competent court. Apart from prorogation on jurisdiction, there is also a possibility that the defendant submits to jurisdiction of a court before which he or she was sued or it was sued, so a tacit prorogation. And there are also rules on special jurisdiction for matters relating to a contract and general jurisdiction. And Article 7.1 represents the rule on special jurisdiction for contracts. This term, matter related to a contract, has an autonomous meaning. There is an autonomous interpretation by the Court of Justice of the European Union by which it is enough that one party freely assumes the obligation towards the other party. So it's, let's say, from the perspective of Croatian law, it's much broader understanding of a contract. In any case, the relationship between the ship owner and the manufacturer of AI in mass will fall, at least in our example, will fall into the ambit of this provision. And now there are several jurisdictional rules in Article 7, paragraph 1. So point A says that jurisdiction should lie with the courts for the place of performance of the obligation in question. And then B specifies what is the place of performance of the obligation in question for two most common types of contracts. And this is sale of goods and provision of services. So the relationship between A and B is that B has priority. So if it's a contract for the sale of goods and provision of services, the competent court will be where the goods were delivered or were supposed to be delivered, or in case of provision of services where the services had to be provided. And now how to characterize the contractual relationship between the ship owner and the manufacturer of AI. So this acquiring AI cannot be characterized as sale of goods. Why? Because from the perspective of European private international law, this is a licensing agreement. So the party who is acquiring, in this case, the ship owner, does not buy the goods. A small portion of that contract may be characterized as sale of goods, but that would only refer to a physical medium if the ship owner is acquiring the AI on that physical medium. The rest of the contract is most likely the rest, because there are possibilities that some other contracts can also be part of the relationship between the ship owner and the manufacturer of AI. And how do we know that this is a licensing agreement? There is a case by the Court of Justice of the European Union in which Falco Privatstiftung, which was an Austrian foundation that was managing the rights of the deceased Austrian singer Falco, you know that song, Rock Me Amadeus, yeah? And that company, that foundation was in a dispute with defendant from Germany who distributed recordings of the concert of the singer. And when the dispute arose, the issue was which court is competent. So which of these provisions can be applied? And the Court of Justice of the European Union explained that this is not provision of services. Why? And it gave an autonomous definition of provision of services. It said, in order for a contract to be characterized as provision of services, there has to be one party who is actively performing something and getting a remuneration. And it said that since in licensing agreement, all that this party was doing was allowing the other party to use the object of the intellectual property. So we have crossed the point B entirely. Therefore, licensing agreements fall into the ambit of point A. And this is quite complicated from the perspective of jurisdiction. Why? Because place of performance of the obligation in question does not have autonomous interpretation in EU law. And this derives from an old case, Dunlop versus Tessely, in which Dunlop, you all know, the manufacturer of sports goods, ordered ski suits from Tessely, and these suits were of low quality. They started ripping at the seams, and the clients were objecting to the quality, so Dunlop sued Tessely. And there was an issue how to determine place of performance of the obligation in question. So Tessely claimed, I have done my part when I transferred the goods to the carrier. So I have performed my obligation in Italy. Dunlop, on the other hand, said, no, the obligation is to be performed in Germany, where I was supposed to receive the goods. And the Court of Justice, and this is one of the rare examples where it did not resort to the autonomous interpretation, said the place of performance of the obligation in question will be determined based on applicable law. And that means that at the point in time when the court merely has to establish whether it has jurisdictions, it has to first establish the applicable law and then look into the provisions of the applicable law, what is considered the place of performance of the obligation in question. Now, when Dunlop in Tessely, in that case, I think it was the late 60s or something like that, or early 70s. So Brussels Convention, the predecessor of the Brussels 1 bis was in force. There was no point B, so only point A was present in the Brussels Convention. And then later on, the European legislator introduced B, which is called Tessely provision, in order to facilitate establishing jurisdiction for two most common types of contract. But for licensing agreements, we still have to do this task. It is a bit simplified today because there is regulation which unifies rules on applicable law. And this is Rome 1 regulation. So member states, courts of all member states would do this relying on the provisions of Rome 1 regulation. And here we are still not done with the issue of jurisdiction, because as I said, definitely this contract will be characterized as a licensing agreement, but it also may have elements of provision of services. For instance, if the manufacturer has the obligation of installing the software or maybe managing it, so this will be characterized as a provision of services for point B. Now we have options. If there is a dispute, are we going to split the contracts in 2 or 3 and then establish jurisdiction for each? Or are we going to put it under the ambit of A because we cannot decide? So there are conflicting opinions on that. When we reach the issue of applicable law, so as I said, Rome 1 regulation contains rules on conflict of law, rules for contracts. And under Rome 1, parties may agree on applicable law in accordance with Article 3. But if they do not use this option, then Article 4 will be used. And Article 4 is structured in a way that it contains first the catalog of contracts. So we have provision of services, sale of goods, and so on. But there is no licensing agreement in the list. And then when we reach paragraph 2, it says that if the contract is not covered by the catalog or it has elements of various contracts, then we should try and establish the characteristic performance, or more precisely, the applicable law will be the law of the country where the party who is performing the characteristic performance has his or her habitual residence. Now, what is characteristic performance? This is actually the gravity of the dispute. So we have to think which of the parties is generating some sort of new value and putting it on the market. So in our understanding, this would be the manufacturer of AI, but this is not clear cut. So it is upon the circumstances of the case and upon the court to decide that. It would be very advisable for parties in these kinds of relationships to choose competent court, but also choose the applicable law and avoid all these conundrums. Eva has mentioned in her presentation the regulation on artificial intelligence, which was introduced in June this year. And AI Act, as we call it, has a pretty broad scope of application. So it says in one of the first articles that it applies to whenever AI is a safety component of a product or a product itself, and is governed by the existing union legislation. And then the regulation contains in Annex 1 the list of union legislation. And among these directives and regulations is the directive on, I think it's called on marine equipment. And marine equipment is defined in accordance with that directive as equipment for which the flag state has to give approval in accordance with Colreg, SOLAS, and MARPOL? Yeah, probably. So definitely AI in mass would fall into that category. And now AI Act contains rules which private international lawyers call overriding mandatory provisions. And this is a special technique that private international law uses to solve a dispute which has an international element. How? Not by using conflict of laws rules, but by directly solving the dispute. So the approaches or methods of solving private international law cases goes like this. So overriding mandatory provisions are first in the hierarchy. Then there are special rules contained in international conventions, which there are many in maritime relations, which also directly solve a dispute. And then at the below are the conflict of laws rules. Okay, and overriding mandatory provisions, they are provisions of substantive material nature. And Rome 1 regulation defines them as provisions which are crucial for functioning of a state from the perspective of policy, safety, and so on. And definitely rules which are contained in the AI Act would fall into this category. Maybe not all, but certain would definitely fall into the category of overriding mandatory provisions. And this can be derived from the recitals of AI Act, which refer to Charter of Fundamental Rights and mentioned that it was necessary to adopt this act to assure the safety, health of consumers and so on, because AI poses serious risks to society. And that means that if we characterize rules of AI Act as overriding mandatory provisions, that means that these rules would apply irrespective of the applicable law. So even if parties choose the law of a third country, overriding mandatory provisions would override them, as the term suggests. Okay, so this is actually the approach that EU has had for some time now. It is similar with the data protection regulation, which is a combination again of overriding mandatory provisions and public law rules. And in this way, EU imposes the third states a regulatory standard. And this is also the way I have heard from the previous presentations that a particularly problematic are situations in which the remote operations center might be domiciled outside of the EU. So by using overriding mandatory provisions, of course, if EU court is competent, it could bring these stakeholders under the regulatory umbrella of the EU and impose its standards. And as far as the relationship between the ship owner and the remote operations center is concerned, this relationship would also fall into the category of provision of services contract, and the competent court would be the place where the service was to be provided, which also may be problematic to identify. And from the perspective of the applicable law, there is in the catalog of Article 4, paragraph 1, Rome 1, a specific indent which deals with provision of services. And both manufacturer and remote operations center would be covered by AI Act, because there are different persons AI Act refers to, like a distributor, importer, provider, and deployer. And there are obligations which are prescribed for certain categories of stakeholders, and then there are obligations which are imposed to all of them. And both manufacturer and remote operations center would fall into the persons identified therein. So I understand I'm running out of time, so I'd like to conclude here. Thank you.